All right, I'm Ben Burgis. This is Give Them an Argument. I am joined by York University law professor Heidi Matthews. I think for the first time on this channel. I feel like back in 2019, 2020, I was on a fair number of YouTube split screens with you, but I think those were always on other shows.
That sounds about right.
Fair enough. The sort of genesis of this conversation is that a week ago, when the International Court of Justice made its provisional ruling in the South African genocide case against Israel, I had tweeted about it in kind of a pessimistic way, and you replied that maybe kind of following the lead of a lot of the Western media coverage of it. I was maybe like missing how big a deal some of this was, and kindly offered to kind of come on the show and lay some of this out. So, I mean, you want to just do you want to just kind of start by giving us a little bit of of context about the case overall?
Yeah. What did you say? What was the tweet? I forget exactly. No, because
Yeah,
it was very pessimistic. I was.
Yeah. What you're pessimistic. So the gist of it, I don't have it in front of me, but the gist of it was that because like the headline that a lot of people were getting out of it was, and of course, what the Israelis themselves were playing up was that they didn't, one of the things they did not give South Africa was the actual ceasefire order. So I said something, cynical about like, hey, okay, it's nice that, the overall ruling seems to be recognizing what's going on here, but it says something pretty depressing about the state of international law, that they're not even going to do the unenforceable order to stop. And you'd said, essentially, what I just said, that this is sort of putting the emphasis in the wrong place, and that the ruling is maybe more of a big deal than that gives it credit for.
Yeah. I mean, I think so. Focusing on the question of the ceasefire and the fact that it wasn't ordered as South Africa had requested, I think, it just plays into kind of the hand of the mainstream media and also Israel itself, right? So what they want us to think is that the ICJ's ruling was a failure in some way for Palestinian rights advocates, just because of this one fact. When in fact, I think within the legal kind of commentary, it is just generally accepted now that this is an incredibly impactful decision. We can talk about exactly why. And I also think it's important for folks to think about the kind of the limits of the law in general, right? So we often think, we expect too much of the law, and then we're always unsatisfied when it doesn't like solve all of our problems, right? And the thing, all law, including international law, is set up to serve the interests of the powerful. And so in international law, that means it's set up to serve the interests not only of states over individuals or other kinds of collective groups like nations, peoples, etc., right? But obviously then also the most powerful, the richest states, right? So international law is like, always already a very tricky thing to be dealing with, and a tricky thing to expect too much out of, right? It's just never going to be, law itself is just not going to solve all of our political problems. It only makes sense if we think of it just as another tool of politics, right? So just another way of making political claims kind of real in the world. And there are lots of different ways that can happen. And specifically with respect to the International Court of Justice, I mean, technically, they could have ordered a ceasefire. As you say, it wouldn't have been followed, right? So although the orders of the court are binding, doesn't have itself any enforcement mechanism. It can, decisions of the court can go to the Security Council, but of course we know what would happen if a ceasefire order went to the
Right, of
Security
course.
Council, right? So there's really it wasn't a sort of real expectation that a ceasefire would come out of this. This is a court of law, and again, not the Security Council or another kind of political body.
Yeah, so I think it kind of sure, for sure, right? Like I think you're obviously right that there's no way a ceasefire was going to come out of it. I would point out that, even the original tweet, I'm very open to being told why why that's too pessimistic. I want you to cheer me up right now, but but in even the original tweet, of course, kind of takes it for granted, right? That a ceasefire, wasn't going to come out of it, right? But the fact that they weren't even, that they weren't even going to issue the unenforceable instruction, right? Did still strike me as initially depressing. So I want to get a sense, I think both of why, even that maybe wasn't like a reasonable expectation at this stage, but also, maybe more importantly, what is in the ruling, and why, and why that's a big deal, right? Because I think if you've kind of paid a little bit of attention to most coverage of this, I think that what you get out of that, right, is that the court said things that were favorable to South Africa's case, that they were saying things that the Israelis didn't like, but they weren't ordering the ceasefire. So what did they, like what is the actual, binding orders that come out of this?
Mm-hmm.
There's no enforcement mechanism, and why is what they did say a big deal?
Right. So for a few reasons. So there's 6 measures, provisional measures as they're called. That just means a form of interim relief, right? So it's a way of the court doing something to try and protect the rights here of Palestinians living in Gaza, not to be subjected to genocide or the threat or a serious threat of genocide up until such time as the case can be decided on the merits, which will take a long time, right? So it's a way of not actually at all deciding the questions that will be for the court to decide on the merits, but using a much lower evidentiary threshold to decide whether provisional orders are indicated or merited in the case, and we could go through that test. But in the end, what it did find is that 6 provisional orders were indicated in the circumstances of the case, and it did so by like a massive majority as well. So this is not some kind of like close decision. Even Justice Barak, right, the Israeli former Supreme Court justice, very very famous in Israel and indeed, all over the world, in particular for decisions he rendered at the height of the war on terror in Israel around national security questions and the application of international law. But even he actually came down on side with the majority with 2 of the measures indicated. So the measures are as follows, right? The court says that Israel shall take all measures within its power to prevent the commission of acts of genocide, okay? It also needs to ensure that its military does not commit acts of genocide. Israel must take all measures within its power to prevent and punish direct and public incitement to genocide. And that's one of the ones that Barak was on side with. So that was a 16-1 vote, right? The 4th measure, Israel must take immediate and effective measures to enable the provision of urgently needed basic services and humanitarian assistance to address the adverse conditions of life faced by Palestinians in Gaza. Again, Barak came down on side there, 16-1. Number 5, take effective measures to prevent the destruction and ensure the preservation of evidence of genocide. And then lastly, Israel is required to submit a report within 1 month of the of the ruling. So they've got about 3 weeks left now to do that. So the court's not looking away, in other words, right? Like Israel's been asked to take these steps, but it's not like the court just goes away then and comes back in a couple of years, to render a decision on the merits. Like, no, the court is taking what we might think of as a supervisory role here, looking over the shoulder of Israel, in some sense, piercing the veil of Israel's sovereignty in that respect, to be like, to say, actually, it's not up to you to conduct the war in the way that you feel is necessary. We don't trust you. Effectively, this is what they're saying. We don't trust you to comply with international humanitarian law, in particular, such that it doesn't, the conduct of the war doesn't tip over into the realm of genocide or the threat of genocide. So all of that is super, super impactful. And for the court to say that, in this particular case, right? So in a situation where we have a conflict that's being, really, it's not just Israel waging this war, it's the United States waging the war as well. For the court to come down with this strong of a ruling is massively impactful. And in terms of so that it's just like impactful in terms of ideas, right? So it changes the way we think about what's happening on the ground, and it changes the way we can talk about it. And that's hugely important politically, right? Like we all know that. The words that we use and the way we put them together to make our arguments really matters. And so I'll just give like a concrete example. I was talking to students the other day, and this was a useful one. In Canada, where I teach and live, there is a very famous former Supreme Court justice. She's recently retired. Her name is Rosalie Abella. She's well known for being, and in some ways the not equivalent, but of the Justice Baroque of Canada, in the sense that she really sees herself and her kind of jurisprudential legacy as having been around advancing the cause of human rights. In particular, legal case, coming out in favor of causes of action for activities of, for example, Canadian extractive corporations operating abroad and committing massive human rights violations. And so that was this is like her legacy. She also talks a lot about, the legacy of the Holocaust, never again, and atrocity crimes and stuff. And it's a very well-known figure, tours around the U.S. and other countries all the time, giving talks at law schools and this kind of stuff. And she wrote this like just absolute abomination of an op-ed in Canada's sort of mainstream centrist national newspaper, the Globe and Mail, essentially saying that it makes a mockery of the concept of genocide, or denigrates the concept of genocide in some way to even conceive of applying it to Israel. So the idea is, it's really just, this is like Israeli government talking points. The real genocidal party here is Hamas. And because of Israel's special history with the Holocaust and the fact that even the concept of genocide as it exists, both in the English language and kind of in the legal sphere in general, only came about, as we know, in the wake of the horrors of the Holocaust. And so she's basically saying Israel's like immune from charges of genocide, which is, very problematic, obviously. She did that just a few weeks ago. Mm-hmm. I think it would be almost inconceivable for somebody with that kind of like professional stature and place in the world, who's a very powerful political actor, right, in the world, to write in that way now that we have this decision from the International Court of Justice. And that's because in order for the court to have been satisfied that these provisional measures were in fact indicated, it needed to find a couple of really important things about the evidence that South Africa presented to it, right? And those two things are as follows. The court needed to hold that Palestinians in Gaza are at a serious risk of genocide at a minimum, right? In other words, the right of Palestinians in Gaza had to be, the right of the Palestinians in Gaza to be protected from genocide had to be at a minimum plausible. The court doesn't need to find more than that. So a lot of folks have been like, they think this idea of plausibility, you know, and I understand if you're not thinking of it in terms of a legal test, you think, oh, well, lots of things are plausible. It's a very low bar. And indeed, it is a low bar. But that's part of what's so important here, right? Is that it wasn't difficult at all for the court to say that it was plausible that there was, at minimum, a risk of genocide in Gaza. And it just doesn't answer the question of of how substantial or how plausible that risk actually is, because it doesn't need to in order to answer rather the legal question before it. So, you know, as a general principle, courts don't go beyond what they need to with the evidence in order to answer the legal question before it. And that's why we have this language of plausibility, not because genocide is not more than plausible, not because it's not probable, not because it isn't happening, not any of those things. It's just because that was the legal test in play, and that's the language the court had to use because it was that jurisprudentially. And then, you know, secondly, we've got plausibility. Okay, the court then needs to find that there's a serious and imminent risk of harm if orders aren't indicated. Right. So what that leaves us with is a serious and imminent risk that Palestinians in Gaza are or will face genocide. And that's huge. And it has massive repercussions for domestic legal systems. We could talk a little, I know I've talked quite a bit now, but it matters in terms of the enforceability point, because then everyone will say, well, you know, it's all just international law and that's not really law anyway, and the Security Council is not going to act here, and so ultimately what's going to happen? The thing is, that finding that I've just described, the real and imminent risk of genocide in Gaza, that formally triggers every state who's a party to the Genocide Convention, which is like 140 states, I believe, maybe more now, including the U.S., right? All of those states are now formally on notice that this risk of genocide exists. And that triggers their legal obligation under the Genocide Convention. So it's a treaty. It's basically just a contract, right? It's like that. You know, the U.S. has signed this contract. It has an obligation now, given the risk, to take concrete steps to prevent genocide, right? That's true of the US, it's true of Canada, it's true of Australia, the UK, whatever, all these countries, right? So now, domestically, we have a decision from the International Court of Justice that can have really concrete impacts at home. And we saw that quite recently, I think it was yesterday, actually, the lawsuit that was heard recently in federal court. It was dismissed on jurisdictional grounds. It brought by the Center for Constitutional Rights. It was seeking an injunction against Biden and other members of the administration for complicity in genocide. So it was widely expected that would be dismissed. It was dismissed. But and folks can read this, in the decision, the judge takes pains to point out the finding of the International Court of Justice and to urge the Biden administration to evaluate the situation on the ground in Gaza and to act accordingly with respect to its own domestic legislation. And so there are a whole bunch of other ways too that this will have impacts, right? So countries like Canada and the US and the UK will have obligations around when they are permitted to export arms or other kinds of military goods or technology that could be used to commit serious human rights violations or violations of international humanitarian law as well. And so there's litigation just getting off the ground in Canada, trying to stop the federal government from issuing arms exports for Israel, for example. So there are a bunch of different ways that this international legal decision can have a really concrete purchase in domestic legal systems.
Yeah, no, that's helpful. I guess okay. So one question is, presumably Israel is not going to meaningfully do any of that stuff in the next few weeks. Like one of the injunctions you mentioned was to crack down on incitement to genocide, which has which is something that's I mean, whatever, they're like 12 pages, I think, of the original South African filing of just like examples of
Yeah.
this. And those include from the ceremonial head of state, Isaac Herzog. They include from Netanyahu himself. They, certainly plenty, lots of politicians in his party, members of his cabinet. None of that, for example, is going to be, cracked down on in any way. You can maybe imagine a bit more humanitarian aid being, allowed in, etc. But I mean, like, they're, it in a substantive way, it seems overwhelmingly clear that the Israelis are going to keep doing what they're doing, right? So, assuming that that's the case, and I guess like Israel's invested enough in these institutions that it will like make some sort of report, but then what happens after that?
Yeah. So I've actually, I mean, what's already happened is really striking, right? We can talk about that too. So on the same day that this ruling came down from the ICJ, what do we see? We see, I mean, and I have to say, I shouldn't be shocked, but I was a bit shocked for a couple of hours. When, just a few hours later, the Biden administration says, "Oh, actually, we're pausing all funding to UNRWA." UNRWA is, for those who don't know, it's the organization that's specifically mandated to deal with providing assistance and other humanitarian and life-saving services to Palestinian refugees. And there are many millions of registered Palestinian refugees, and these are refugees from the Nakba, right? So we can talk about UNRWA. UNRWA is a very problematic organization, I will say, right? Because it keeps Palestinians in this like exceptional limbo kind of situation where they're not all Palestinians, but those who are refugees, registered as refugees, considered outside of the general refugee framework that was established in 1951, which is already hugely problematic. So, don't take anything that I'm saying here about like the existence of UNRWA as sort of like a wholehearted, naive kind of endorsement of the organization. It's really not that. But the organization is the biggest provider of aid in Gaza right now, and in the situation of humanitarian catastrophe, imminent starvation, complete collapse of the medical system. Everything that we know is happening in Gaza. We need someone to deliver aid, and who's going to be able to do that right now? It's UNRWA. So the U.S. defunds UNRWA. And then, a couple of hours later, it's the UK, and then it's Canada, and then it's Switzerland, and then it's Australia, and whatever. There's like a whole laundry list now of countries who seem to have essentially like colluded in some way to come up with this policy. And folks have talked about that as creating a distraction from the headlines of the ICJ. So I think that's true. So one strategy was just to get the decision wrong by creating headlines that spin the decision as a failure because it didn't, or because there's no ceasefire, right? So totally misconstruing the impact of the decision. Then governments themselves completely misconstrued the decision. So you've got like, John Kirby standing up saying, this decision is totally consistent with U.S. policy on Gaza, because we are saying that Israel has to comply with international law, and that's what the court's saying, and therefore there's no inconsistency. And of course, that's not at all true. The court's saying there's a real and imminent risk of genocide, right? Which is a very different
on its face, not consistent with a policy of providing arms and money and unconditional diplomatic support to carry out the operation that bears this imminent risk of genocide.
Yeah, exactly. So the thing is too, like in terms of additional impacts, right? For states who do continue to bankroll, provide arms, provide diplomatic cover, all kinds of other modes of participating in or facilitating the actions of Israel and Gaza, may themselves now be liable, both in terms of state responsibility So, for example, potentially at the ICJ themselves, but also their officials may bear individual criminal responsibility for complicity in genocide, and that's important to point out. Complicity is just an umbrella term to understand all the different modes of participating in a crime without being, the person who's physically doing the crime themselves. And there's a lot of ways you can get to that point. Yeah, so Israel's been targeting UNRWA for a long time, and specifically in the context of the conflict in Gaza, holding all kinds of like special meetings at the Knesset and stuff to try and figure out how to just like dismantle UNRWA once and for all. And it seems that they've gotten a large contingent of Western nations on board with that, which, to my mind, is clearly inconsistent with what was ordered in the ICJ ruling, right? So even though the ruling technically is binding only on the parties to the conflict, I mentioned before, it creates this obligation, this special kind of obligation that it's the Latin term that lawyers use is they call it an erga omnes obligation. It means that genocide and the prohibition of genocide is so important in international law that the duties that states owe one another under the Genocide Convention are owed not just to people who might be subjected to genocide, but to every other state in the whole world, right? So there is a special kind of obligation that's now been triggered, and I think the argument, it's not too far to go. It's not a difficult argument to make to say that defunding UNRWA will contribute to the further deterioration of the humanitarian situation in Gaza, which is absolutely inconsistent with the fourth provisional measure to take immediate and effective measures to actually provide humanitarian assistance, right? And so to my mind, any state that contributes to that deterioration is potentially complicit, at least in creating the further risk of genocide and perhaps even in genocide itself.
Yeah, and I mean those humanitarian conditions. I mean, there's mass starvation. There's the overwhelming majority of the population has been displaced from their homes. It's already talk about deteriorating conditions. I mean,
Yeah.
these are conditions that are already catastrophic. And as I understand it, the official rationale for defunding it is that there's a tiny number of employees, who are accused of, being involved in Hamas or, specifically, October 7th, which, strikes me as like a good argument for arresting those specific people, right? But largely irrelevant to the work done by the agency as a whole and you know, the overwhelming majority of the people who work for it.
Yeah, no, and I mean the director of UNRWA has said this, and I think it's quite right that this kind of mass defunding or pausing of funding to UNRWA is just amounts to collective punishment, which is also a war crime. So,
Right.
Yeah.
Right. Okay, so yeah, I guess the last thing I wanted to maybe circle back to was just the question, because we've talked about like what's already happened, since the ruling came down. I mean, in that case, like right after the ruling came down, in a way that makes it seem like it's immediate retaliation. That they, at least this is the time they rolled it out. But yeah, I guess the last thing I'm curious about is your thoughts about what I was raising a minute ago about what would or could happen going forward. Because presumably one thing that's almost certainly not going to happen is that Israel is going to meaningfully carry out all of these instructions from the court. And so I mean, I guess this goes a little bit to I mean, some of the questions we were talking about earlier about enforceability and all of that, but like what's the what is the Israel doesn't do any of this stuff scenario look like, right? I mean, is like what is that? What does that trigger? Is there, I mean, are there meaningful things that could happen as a result of that?
Yeah. Well, the court remains seized of the matter, right? So it's not just that Israel has to report; like the court has to evaluate what's in the report, and so it's like providing this, and also South Africa will have a chance to respond to the report as well. So it's an opportunity for additional information and evidence to come before the court. The court is certainly not, hamstrung by its own measures in a particular case, right? So again, it just will remain seized of the matter. But I think, again, I think you're right, though, that fundamentally Israel has always said, Netanyahu and others in the government have said from the beginning that they're taking the case seriously in the sense that they have compiled and sent like a very skilled legal team to address the matters, right? They're making their case. It's important. What's interesting, actually, if you watch the hearings, it was very important for Israel's kind of national self-conception to get up on the podium, whatever, at the World Court to make the kinds of submissions that did. So it felt as an observer, it felt genuinely meaningful to the folks making the argument that they would that Israel was born of the Holocaust and therefore it's preposterous to talk about Israel potentially committing genocide. So all of that stuff has meaning too. You can think back to the Eichmann trial in the 60s, an extremely important kind of spectacularized theatrical event in the construction of the identity of Israel, and then also a kind of sense of national memory. And folks, are talking about putting together another quite spectacular trial, to deal with October 7th, for example. So I think there are these it's not just kind of what the law can do, but how the law helps us tell stories about ourselves as communities, as political communities in particular, right? And so I think that goes both ways, right? So a lot of the celebration around even the fact that South Africa brought the case in the first place, right, and put together such a compelling application and put together such a compelling legal team that really did deliver, a just excellent oral argument at the court, that it's totally independent of whether these measures are going to be complied with or not, or whether eventually down the road Israel is going to be found to be responsible for genocide or any of those questions, right? That moment was very, very meaningful, I think, for any of us who are active in the kind of struggle for Palestinian human rights and self-determination, right? That felt meaningful, and I think that's real and legitimate, and I don't want people who felt that to be dissuaded, to fall into nihilism, right? And it's easy to do that. It's easy to say, oh, well, we didn't, this is not going to be the solution, or it's all going to be for naught, or international law is whatever, because those moments are real, and they fire up the energy needed to do activism in civil society. And as well as I do, how difficult it is, even for those of us who are very, very privileged, and hold, positions of some kind of power, we have jobs or whatever, and have some kind of position or platform in the world. It's really, really difficult to do this work right now. And so rather than throwing away these, hope is a strong word, but these moments that aren't necessarily hopeful is a bit weird, but that offer us something to hold on to that isn't just nothing, it's real, right? The fact the global South kind of fighting back here it's not just a slogan, it's actually happening. And so it's up to civil society effectively to take this decision to number one, understand what it says, right? So not to be misled by mainstream media into thinking that this is a nothing order. It's not. So number one, to understand what it says and why it's so important, and then to take it to your government and say, why are you exporting arms? Or I don't know, to your university, why do you have this investment, or why do you have this partnership with this university, or whatever, like all these different ways of pushing concrete action forward on the basis of a legal decision that says something incredibly meaningful around, again, like the real and imminent risk of genocide.
Well, cannot possibly have a better place to wrap it up than that. So that was so well said. Thank you so much, Heidi.
Awesome. Take care, Ben.
Bye.